Good morning, Your Honor. Rory Kay of McDonald, Toronto, on behalf of third-party defendants, Spin Games, LLC, Kent Young, and Kunal Mishra.
Good morning, Your
Stephen
Honor.
Clario on behalf of third-party defendants. Good morning, Your Honor.
Good morning, Your Honor. Brenoch Wirthlin on behalf of third-party plaintiffs. Mr. Mahon and Mr. Howard are here with us as well.
Good morning, Your Honor. Jeff Hewitt on behalf of Full Color Games Inc.
Okay.
We also have Todd Kroll and Shelby Dahl on behalf of third-party plaintiffs.
It's entitled Plaintiff's Ex Parte Application for an Order Shortening Time on Motion for Stay. I think it's basically the motion for stay that's before us, not a motion seeking an order shortening time, right?
Yes, Your Honor. That's correct. We do very much appreciate the court allowing us to be heard today.
As you know, I've now issued a ruling or an order that's scheduling a bifurcated portion of the trial.
Yes, Your Honor. We reviewed that, I believe, about the day after we filed our motion for stay, and we appreciate that ruling. What we put into footnote 3 in our motion for stay, we noted that in the event that there was a denial with respect to the relief requested in the motion, that we'd be seeking a stay to file a written petition. And here's the reason that we're in front of Your Honor as well. They reached out to us and said, well, is the motion moot? And we said, no, we think that there's still this issue with respect to the 5-year rule, at least it's to their contention, that we feel probably requires a writ. And that is this, Your Honor. The court granted our request to bifurcate and granted our request for a preferential trial setting as to the injunctive relief claim. We appreciate that. And we want to be careful, Judge. We're not, we don't want this to be a situation where we just need to take yes for an answer. The reason that we came back in front of the court on this request for a stay is because we've got a little bit of a unique position. The request to bifurcate was granted, the request for preferential trial setting on the injunctive relief claim was granted, but the third-party defendants have made the argument multiple times that the 5-year rule runs on November 26th of this year, so in about 6 days, about a week. We disagree with that, as the court's well aware. I don't want to rehash that argument, but the situation that we have, Your Honor, is that if the relief that we requested was granted, but with the time frame, obviously the trial on the injunctive relief claim, the preferential trial setting won't take place. Within that undisputed period, that clearly is both sides agree within the 5-year rule. So we believe that out of an abundance of caution, that a stay for all purposes is appropriate for us to go to the Supreme Court.
All right. That's okay.
I do have one additional request, if I could, Your Honor, just because we believe that there's a different situation that could resolve that issue, and we would request that as well, Your Honor. We have Mr. Howard and Mr. Mahon here available. It came to our attention after we filed the motion that in a case before this court, for Your Honor, Sunato versus Euler, it's A-15-718-636-C. The court permitted a witness to be sworn in and then suspended the trial to start that running of the 5-year rule. We would request, Your Honor, the ability to swear them in only to then suspend the bifurcated portion of the trial on the injunctive relief claim. So that 41E requirement could be met. We would reserve time for opening statements and certainly would give the third-party defendants all the time that they feel is necessary to prepare for cross-examination.
Okay.
Yeah, Your Honor. Rory Kay for the Spin third-party defendants. I'm going to start with Your Honor's first question. This is moot. They filed the motion to stay and very clearly asked on page 5 of that motion for you to stay this case. And I'm going to quote here, pending a decision on the motion to bifurcate. You issued that decision. This motion is moot. Now, the goalpost switched a little bit to this footnote 3 where they said if you don't give them everything they want in their motion, they're going to file a writ petition. There's no proper NRAP 8 analysis with respect to that writ petition and motion. But again, I don't believe it's ever been this court's practice to grant stays on the theoretical possibility that some writ petition may be filed at some point in time in the future. If they get a writ petition on file, maybe this is a different discussion. Maybe they can then move you to stay under NRAP 8. The other problem is even if Your Honor were to go to those factors, of course, we all know one factor is likelihood of success on the merits. That is not present here. They have a plain, adequate, and speedy legal remedy. If we file a motion to dismiss under the 5-year rule and Your Honor grants it, they have the right to make a 3A appeal. So there's sort of 4 different independent grounds to deny this motion. With respect to the, and I think this gets at the core of what they're really asking. They're asking you to stay this case solely for the purpose of Rule 41E, which they cannot do, otherwise the 5-year limit rule, or the 5-year deadline would be illusory, certainly not what the case law suggests. As to swearing in a witness, Your Honor, we haven't had any pretrial disclosures under 16.1. I obviously don't have my clients here, Mr. Clario doesn't have his clients here. We're all very clear on the pretrial obligations. Your Honor gave them exactly what they wanted in their motion. You gave them a preferential trial setting on the injunctive relief case. You bifurcated it. And you set it under the years, or under the deadline that they believe the 5-year rule exists. So there's no justification for a stay under any of the bases provided. I'm happy to answer any questions you have, Your Honor. I just think we are where we are in this case.
Okay, thank you. Absolutely.
Yeah, very briefly, we did address those state factors. The first of which, in our motion, in the event that the relief we requested wasn't granted or within the time for the request. And what I want to focus on, Your Honor, is the object of the writ would be defeated if a stay is not granted. And the writ would simply be just that we would request that the trial be able to be started within the remaining 5-year rule period under their analysis. Again, we do believe it's different, but that's the only request that we would ask for because the court did grant the bifurcation of preferential trial setting. That limited issue, though, I know they want us to wait. They're trying to use that down the road. But we believe that merits the writ.
What writ would you be seeking if I granted your motion for a stay?
Exactly, Your Honor. That's why it's a very, very narrow ask. The only request we would be asking is that within the week, because right now there's at least 1 week, they don't even dispute the 5-year rule doesn't lapse, right? That's before November 26th, so basically 1 week left. So what our request, the only request on the writ relief would be, Supreme Court, can we have permission, because the case would be stayed, if the court granted the stay, Supreme Court, can we have permission to just start the trial, swear in a witness, so that technical requirement under 41E is met? So the stay would then be lifted for that remaining 5-day period.
I don't see any further hearings coming up in this case in the near future, okay? So here's what I'll do. I'll grant a temporary stay 20 days from today,
20 days.
and you can seek further stay in the Supreme Court. All right?
Thank you, Your Honor. Appreciate that.
So that's it. All right? You can seek further stay in the Supreme Court. You've applied to this court first
Yes.
and granted a temporary stay and go to the Supreme Court if that's what you're going to do and seek further stay. All right?
We'll do it. Thank you, Your Honor. Appreciate that.
Yeah, we'll live with the ruling, Your Honor. If we have anything we need to bring back to you, we will.
Okay.
Thank you very
well. Thank you.
Have a good holiday, Your Honor. Thank you.
You too. Thanks.